Hi everyone, my name is Dia and welcome to our group presentation on understanding intellectual property law in Canada. Today we will explore what is intellectual property or IP is, why is it important and how it protects under Canadian law. Our team includes Shubham, Hani, Kusum and myself and each of us will walk you through different type of IP with examples and key takeaways. So let's begin with a quick overview of what we're going to learn today. So what we're going to cover in this presentation. First, we will define IP. Then we will introduce five main types, which is trademarks, patents, copyrights, industrial design, and trade secrets. Then we will highlight how these law works in Canada, why they matter, and how they protect creator and businesses. We will also include real world example and finish with a quick quiz to reinforce your understanding. Now that you know the plan, let's get into what is intellectual property is. Intellectual property refers to creation of minds like logos, invention, artworks, and even mobile apps. In Canada, these creations are protected under specific laws like Trademark Act, Patent Act, and Copyright Act. These laws give creators and companies a legal right over their works, whether they are selling it, licensing it, and or stopping someone from copying it. So why does it all this protection matter? Let's find out. There are several reasons why IP protection is so important in Canada. First, it encourages innovation and creativity by giving inventors and artists credit over their work. It also helps attract investment both inside and outside Canada, especially in fields like R&D, entertainment, and design. And IP plays a major role in Canada's economy by creating jobs and supporting growth across industries. And IP does not just protect businesses; it also helps consumer and society too by ensuring that they receive real, high quality products, not just fake or unsafe copies. IP protection also help Canada stay competitive globally, thanks to the international agreements like TRIP. Finally, it helps preserve Canada's cultural heritage, ensuring that the local knowledge, art, and stories are protected and being passed on. Now that we have understand why IP matters, let's dive into the first specific type, which is trade and its their limitation. Trademarks are a powerful tools to protect brand names, logos, symbols, but they also have their clear limitations. For example, generic words like apple for a fruit or descriptive terms like sweet honey can't be trademarked. Trademarks also cover the product or services you have registered. So someone might use a similar name for something completely unrelated. And if you stop using the trademark for several years, which is usually 3 years, you could lose the right to it. And under the fair use, other can use the similar term truthfully and legally as long as they are not pretending to be your brand. So while trademarks are essential for branding and they come with rules and that the businesses must understand and follow. Now that we have looked into the trademark, Shubham gonna take over and walk you through what are the patents and copyright acts. Over to you.
Thank you, Dia. Next, let's turn to patents. Under Canada's Patent Act, an invention is any new and useful art, process, machine, or composition of matter. Once granted, your patent confers a 20 years monopoly from the application date, letting exclude others from making, using, or selling the invention. This exclusivity is a powerful business tool. You can license your technology out, generate royalty streams, or use your patent portfolios as leverage in cross licensing negotiations. And because patent rights are territorially defined, these benefits apply throughout Canada, which, for a market of 38 billion customers, still represents significant commercial value. So far, we have seen the power of a 20 years patent monopoly. Next, we'll explore the important built in exceptions that balance public research interest as well as protect prior users. However, patents also have built in exceptions to balance public interest. First, the experimental use exception allows researchers to practice a patented invention without infringing. As long as they are not commercially exploiting it, this keeps academics and non commercial innovation alive. Second, under Section 56.2 of the Patent Act protects prior users who were already exploiting the invention in Canada before the patent was already granted. And finally, patents require full public disclosure. In exchange for a time limited monopoly, you must reveal how your invention works. This quid pro quo fuels further innovations once the patent expires. With patents limits in view, let's move on to a different form of protection, which is copyright, which kicks in automatically the moment you create a work. So, moving on to copyrights. The Copyright Act automatically protects original literary, dramatic, music, and artistic work the moment they are fixed in as a tangible medium. No registrations required at all. Copyrights give you a bundle of economic rights. You control reproduction, public performance, and adaptations of your work, which can be monetized via licensing. You also have the moral rights built in under Section 14.2 and 14.1, which lets you insist on correct attribution and prevent derogatory treatment of your creation. Since these rights last the author's life plus an additional 50 years, you and your heirs enjoy long-term protection. You know you know the breadth of economics and moral rights under copyrights. In our final segment, we will be examining the fair dealing exceptions that creates accessibilities. So finally, copyrights comes with important exceptions under Section 29 for fair dealing. So the users can reproduce or adapt work without permissions for the purposes like research, private studies, criticism, review, parodies, or even news reportings. Canada's fair dealing regime is notably user friendly. So the courts access whether the dealing is fair by considering factors such as the purpose, amount taken, and the effects on the market. And additionally, statutory licenses exist for educational institutions and libraries, enabling them to copy excerpts for teaching or either archiving, further striking a balance between a creator's right and the public access. So all these limitations and exceptions ensures that each PI right, whether trademark, patent, or copyright, strikes a fair balance between exclusive economic incentives and the broader public interest. That was all from my side. I'll now hand off to Kusum.
Thank you, Shubham. So now I'm going to start with industrial design. And first, there is a statutory definition. So in Canada, an industrial design protects the visual features of the product, such as its shape, pattern, and ornamentation. So as long as they are applied to a finished item. So it's about how a product looks and now not how it works. It's only how it looks. If you register, you get exclusive right across Canada for up to 10 years. And initial it's a 5 year plus one renewal for another 5 years. In short, it's about protecting a product appearance, not its function. Now there are some limitations. Industrial design protection does not cover how something works. It only covers its look. And if the design has a functional part that needs a patent instead. It's also limited to features that are ornamental or decorative. So you can protect something purely useful like a tool shape that only improve performance. Overall, industrial design safeguard visual features, not functional ones. Next part is I'm going to discuss trade secrets. So the definition is in Canada, there is no single law for trade secrets. They are protected through they are protected through common laws and shaped by court cases. To qualify this, information must be not be generally known, have economic value because it is secret, and be protected by legal steps like uh, NDAs or restricted access. The famous example is the Coca-Cola recipe. So valuable, secret, and guarded. So the next are benefits and limitations. Trade secret can be cover, formula, process, customer list, anything confidential that gives a competitive edges. So no registration is needed, which means no fees, no formalities, just secrecy. However, protection is a loss if someone receives engineers or independently discovers it. So that's why strong NDAs, access control, and employee training are essential for the secret. In short, so trade secrets are powerful, but only if uh, you can keep it safely or secretly. So this is about from my side, and next part we'll discuss by Dhanu.
Thanks, Kusum. Now, on this slide, we have a quick comparison of five main areas of intellectual property. First, trademarks protect brands and logos for 10 years that they are renewable but can be lost if they become generic. Another one is patents cover inventions for 20 years after examination, with research used as an exception. So here, research is an exception. Third is copyrights. Uh, Copyright safeguard creative works for life plus 50 years automatically, allowing fair dealings. Another one is industrial designs. It protects ornamental features for 10 years through registration unless functionally similar. Next is trade secrets. It protects confidential information indefinitely with reverse engineering as key exception. Basically, this table clearly shows how each type differs in scope, duration, formality, and limitations. All right, mini quiz time. So now look at the four options on the screen, and the question for those options is which one is not a good IP enforcement practice? A. Filing early. B. Monitoring the market. C. Ignoring minor infringements. And D. Using NDAs. Uh, Anyone wants to answer? Yes, the correct answer is C. Ignoring minor infringements. Even small copies can snowball, so you tackle them early or the brand erodes, right? Now, here you can see three famous symbols, which are Nike, Adidas, and McDonald's, right? Now, the question for it is which kind of IP rights protect each one? Yes, trademarks. So, why trademark matters? It matters because it gives strong mark, like it instant the brand recognition. It gives the instant brand recognitions and legal firepower against knockoffs. Now we'll see a real life scenario and let's see if you can pick the right one. So the scenario is imagine you design a cool t-shirt pattern that goes viral online, and which the question for the scenario is which IP right seals that pattern or protect that pattern. And the options are A patent, B industrial design, C copyright of or D trademark. Any guesses? Okay, so answer is on the another slide. That's the winner is industrial design. So, why the industrial design is the answer? Let's see that. So, Canadian law protects the ornamental surface for a product for up to 10 years if you register it. Functionality could be a patent, a logo on a t-shirt as a trademark, but the repeating pattern, the look belongs here, and that's why it's industrial design. Now, let's conclude this presentation. Intellectual property law plays a key role in protecting creativity, innovation, and economic interests. Each right has its lane. Trademarks are for brands, patents are for inventions, copyrights are for creative works, industrial designs are for product look, and lastly, trade secrets are for secret sauce. So, understanding these differences is really essential, especially in Canada, to safeguard valuable intellectual assets and maintain a competitive edge. So, that was all from our side. Thank you for listening to us, and we are happy to take any questions if you have.